Okay, good morning. I'm Virginia Gaglianone with La Opinión newspaper, and to my right is Elizabeth Calvin from Human Rights Watch. To my left is Nathan Bartes from the LA District Attorney Office. We are going to have 1 minute for each person to explain the proposition, and then we start with the questions. Elizabeth.
Thank you. There are several things that people tend to not know about California's criminal system. One is that prosecutors, not judges, are often the ones to decide to send 14 and 15-year-olds to the criminal system to face adult prison terms. Another is that California spends $10 billion every year on prisons, and California's laws do not require the majority of prisoners to do anything in prison to improve themselves. They go in, they come out, and nothing happens in between. It's no wonder that many people who leave prison end up going on to commit new crimes. Rehabilitation is unquestionably the most effective tool for reducing crime, and Proposition 57 is about proven rehabilitation strategies to improve public safety. On the front end of the system, Proposition 57 would make it so that judges, not prosecutors, decide whether children go to the adult system. It would make more children be able to be involved in treatment and turn their lives around. On the back end of the system, Proposition 57 would create incentives for people who are in prison through a nonviolent parole process and through credits, strong incentives for them to turn their lives around.
All right, thank you, Elizabeth. Nathan?
When you heard that term nonviolent, how many of you were thinking about rape of an unconscious person, or domestic violence causing traumatic condition, or battery causing serious bodily injury? That's what's so sad, because the title, the Safety and Public Rehabilitation Act, it provides so much hope, but the text provides heartache for the victims of these and other vicious but technically not violent crimes. If this was truly about juvenile justice reform, about the impact, then we wouldn't be having this debate. But the problem is that the governor hijacked the language of a juvenile proposition and added provisions for the release of vicious convicted felons. This is absolutely now about public safety.
All right, thank you, Nathan. Let's start with a question, right, with what Nathan just said. One of the arguments against Proposition 57 is saying that it will allow criminals convicted of crimes like rape be released earlier, from prison. What would you like to say about that?
This is truly one of the most disingenuous and erroneous arguments that the district attorneys are making about this proposition. First of all, we have to recognize nearly everyone who goes into prison gets out at some point. That's our system. We don't lock people away forever and ever for every single crime. They can get out of prison one of three ways: the same way they went in, worse, or better. And right now we have a system where most people who go in prison, 70%, have the type of sentence where they don't have to do anything. They get released. And it doesn't matter whether it was rape, it doesn't matter whatever the crime was, they get released without any self-improvement. Prop 57 will change that and incentivize people in prison to turn their lives around. Right now, people get released without any determination. That people who have these determinate fixed sentences get released without any determination about whether they are fit to be released. Proposition 57 will create individualized decisions about inmates, looking at what their behavior has been and whether they have made rehabilitative achievements. And I'll say one other thing about the red herring of saying that Proposition 57 is going to let out violent criminals. The prosecutors point to a part of the penal code that lists violent crimes, and they say rape of an unconscious person isn't on that list. There's two things you need to know about that. One, the prosecutors wrote that list. They drafted that law. So we might be asking them, why didn't you put why didn't you put rape of an unconscious person on that list? The second thing is, that list, if you read the law, is specifically about one type of sentence. It's about 3 strikes sentences. It's not the list that is going to define who is going to be eligible for this nonviolent parole process. That will be defined by regulations that are created by law enforcement, created by the Department of Corrections. And the proposition requires that those regulations promote public safety.
Thank you. Would you like to comment on her?
Certainly. I mean, first we have the argument that because someone is going to get out sometime, why not release them early? I don't think that that follows in terms of logic. When someone commits more crimes against more victims or more egregious crimes against victims, there certainly should be some punishment for that increased activity. The other thing that she was mentioning is the definition of violent crime. So first off, we would think that if this proposition is talking about nonviolent crimes, it would define that term. It doesn't. So by a constitutional law reading, you have to then go to, well, where is violent defined? The only place it is defined is in the penal code from a section that she points out. But the problem is, if that section is the only one that defines what violent is, that's what we use. And when this proposition is enacted, there are no other regulations that define nonviolent. So we have a list that was designed to increase punishments for particularly violent crimes, and it was never intended to be used as an exclusive list for those crimes for everything else to be released early. Proposition 57 outlines not a single rehabilitative program. It's nowhere in the text. It says it authorizes credits, but does not give calculations for a single one. The other thing it doesn't define is the criminals that this applies to. We're putting the cart before the horse. The text of this proposition does not rehabilitate, it re-victimizes and releases criminals.
All right, thank
I'd
you.
like to just respond to that, if you don't mind.
Okay, yeah, I was
Okay.
going to touch about the rehabilitation. I was going to ask him, you know, he says he will say, you know.
I just want to say, you know, the choices when you draft a proposition are to draft something that's 200 pages long with every single thing put into it, or you can do what Proposition 57 has done, which is require that regulations. You know, he just said, oh, it's not defined, so who knows what it'll be. Proposition 57 requires the Department of Corrections, the agency that is tasked with promoting public safety by keeping people in prison if they're too dangerous to be released. That secretary will draft regulations with public input that define what nonviolent is. The California Supreme Court has already ruled on Part 57 and said that the parole process is about nonviolent crimes. No one's going to be able to twist that and include the types of crimes that he's suggested.
All right, thank you. I mean, unless you wanna
respond to that,
answer?
please?
Yeah, and then
Well, if we're drafting an amendment to the Constitution of the state of California, that is the supreme law of the state of California, at the time that that's enacted, there is only what exists in the penal code now. Future regulations cannot trump what is in the Constitution. And the problem is that you have prisoners who can say, look, the text says nonviolent. At the time we have these lists of violent, I'm not on it, I deserve release. And the point is, we are giving so much power to the parole board to make a determination that has not yet been made. This is the horse, and the cart is sitting in front of it.
all right, thank you. I want to touch a little bit also the part of the juvenile court of the proposition. Do you want to talk about that?
Yes. Right now, California is one of just 14 states that allows the prosecutors to decide to put children as young as 14 into the adult criminal system. And that decision-making power is unfettered. There's no review by a judge. There's no guidelines. Prosecutors can put young people into the adult system where they face adult prison terms. This is just wrong. There is no more single important decision about a child's life than whether they're going to be in the juvenile system, which has treatment and education, requires children to be involved in counseling and rehabilitation, or whether they're going to be sent to the adult system and face adult prison terms. Prop 57 says that decision should be made by judges. And if we pass Prop 57, what it will mean is more young people will get the treatment and the education, counseling, and training that they need to turn their lives around.
All right, thank you, Elizabeth. Nathan, you want to talk about that?
Yeah, when you say more juveniles, this is a very important issue to them. The around 500 juveniles that this would affect per year in the state of California. But this isn't really what the impact of Prop 57 is. This isn't the debate. I might be on the other side if this is what we were talking about. What we're talking about is the text that's added after that that releases up to 30,000 convicted felons out onto the streets. So that's the impact that we're talking about Prop 57. So to talk about the juvenile justice system, really, again, that would be a red herring, because we're talking about a very small percentage. And it's important, and it's something that should be addressed, but it shouldn't have to have the pork of 30,000 inmates being released tacked on to that proposition.
All right, thank you. Unless you want to answer to this, or okay. I understand the Proposition 57 was like a result of the mandate, I mean, in part of 2009 to reduce, overpopulation. I don't know if you want to.
I would like to speak to that.
Go for it.
I mean, this is a reality that I think the opposition is really not addressing. California is the only state in the country that has had the U.S. Supreme Court order it to reduce its population in prison. The population of California's prisons were so inhumane, they reached unconstitutional levels. And California has its prison system basically in receivership. A federal court is overseeing California's prisons and requiring California to reduce its population. Our governor has to report to a federal court every 3 months about what this state is doing to reduce its population. If the state can't prove that it can get the population down to constitutional levels and keep it there, this court will order the arbitrary release of inmates. Proposition 57 is a rational response to that. It says, let's release prisoners, let's comply with this law before a federal court reduces the population with arbitrary release. Let's pick out the prisoners who are working hard. Let's choose prisoners who are making decisions in their lives to turn their lives around. Let's go to the prisoners who are proving through their behavior and through their success in rehabilitative programming that they're the ones who should be released. Right now, that's not what's happening. And on the horizon for California is the arbitrary release of prisoners. And Prop 57 is a good response to that.
All right, thank you. You want to comment about the overpopulation?
Well, clearly, there is an incarceration problem that needs to be addressed. The problem with this proposition is it doesn't truly address the problem. The problem is something that can be solved by involving the community and things like that. But all of this does is prescribe for the early release of people who are already in prison. When you talk about just early release arbitrarily by a judge, that's not what happened in terms of the case. What happened was the judge made the order, and California drafted laws in order to comply with that, and we complied. So it's not arbitrary release as if a murderer is going to suddenly be sprung by a judge's order. That's not the way it works. The second part of what was being mentioned was we should reward those people who are showing that they are rehabilitating themselves. I think everyone absolutely agrees with that position. The problem is, again, the text of this proposition. There is nothing in the text that describes one bit what that would look like, how we would calculate the credits for that person, or who that person is, what type of criminal could qualify. And without that type of language, we're just writing a blank check to the parole board.
All right, thank you.
I'm sorry, that is a misstatement of what is happening. California is under a federal court order. It has not been resolved. The other thing is that court has implemented already a nonviolent parole process, a nonviolent offense parole process that's been in use. That's what Prop 57 is based on, is that process that has already been in use. If you look at the numbers, 6,000 people have gone through that nonviolent parole process. Only 21% have been released under the parole process. And in the first year, less than 14% have committed any type of new crime. These are much lower statistics than what, if you look at people who are released and don't go through that kind of parole process.
All right, thank you. I know we have 5 minutes. I want to talk, address the subject of recidivism right now in jail. And also, I would like to maybe give you 1 more minute each before we are done so you can close. Nathan, you would like to start talking about, how to address the recidivism in jails right now?
I would love to be able to address that, but that has absolutely no point in the text of this proposition is that addressed. That is a moral debate. That's something that we need to talk about that I think your two panelists here might agree upon. But the recidivism rate is not addressed in this text at all. In fact, we have people who are being paroled and they're going out and they're shooting law enforcement officers. We have grave concerns about the public safety by the release and parole of these people. And it's something that needs to be defined before we pass an amendment to the Constitution.
Do you feel that the rehabilitation as described in Proposition 57 is not clear?
There is no description. The text of this proposition says that they want to adopt regulations, future regulations, that are not described and currently don't exist. It's basically aspirational. We would like to do this, and of course we would, but there's nothing in this text that describes what rehabilitation looks like, how it's calculated, or who it applies to.
All right, thank you. I would love to give some time for each one to closure, just to give your final arguments. You want to start?
Sure. Rehabilitation reduces crime. We all know that. People who go into prison and get no access to treatment, education, vocational training are more likely to come out and commit new crimes. That is what California's law is right now. People are not required, they're not incentivized to be involved in rehabilitative programming. Prop 57 would incentivize people to get involved in improving their own lives. And that ultimately is going to make our communities safer.
All right, thank you. Nathan?
Prop 57 does not provide rehabilitation. It provides heartache. Heartache to, let's say, a young woman who's at a bar, gets drugged and raped. And she finds out that her rapist raped 10 people before her, raped 10 people after her. And even though a judge sentenced him to a really long prison sentence, she gets a notice that his parole hearing is coming up 10 times earlier than what the judge said. And now she fears for her safety, so she's going to go to that parole hearing. And she's going to relive the worst day of her life, even though she relived it when she told the cops, when she talked at the preliminary hearing, when she gave testimony in court where she was accused of wanting this to happen to her. She's going to be there, and she's going to have to try to explain why she deserves to be safe. And guess what? If she's successful, she'll do it again, and then she'll do it again. And Prop 57 puts the burden on these victims to maintain their own sense of safety. This proposition does not contain any text about rehabilitation, what it looks like. It doesn't prescribe who it applies to, and it doesn't prescribe how it's calculated. It is about release.
All right, thank you. Do we have time for comment on it?
You know, I mentioned earlier that there already is a nonviolent offense parole process that is being used right now. And every single sex offense is excluded from that process. Every single sex offense. So for the opposition to focus so much on these horrific crimes is really fear-mongering. For them to focus on not everything is defined is to ignore the central fact of this proposition, which is that it must focus on public safety. The regulations have to be certified to promote public safety. The district attorneys will be a part of the public comments on creating those regulations. And so, in the end, Proposition 57 is about making our communities safer.
All right.
Can I briefly respond to that? If she
1
responded,
minute.
yeah, just because this is not from me, from PolitiFact. They took a look at that and said that there was nothing in the court order making the distinction that she just made about the sex offenders. It's not there, and it's definitely not in the text of Prop 57.
All right.
It's how it's
Thank
been
you.
implemented. It's
Okay.
how it's being done.
Thank you very much to both of you. Thank you to all of you. Have a beautiful day.